Let's right now go to John Yoo. John, let's get your legal hat on here, because the president said that he's got alternatives, and he articulated that he's already taking action under some of those alternatives. Listen to what he said.
But other alternatives will now be used to replace the ones that the court incorrectly rejected. We have alternatives, great alternatives. Could be more money. We'll take in more money, and we'll be a lot stronger for it. We're taking in hundreds of billions of dollars. We'll continue to do so.
All right, so that's what he said, that there are alternatives, and here's the alternative actions that he's already taken. This is cut 6 here.
Today, I will sign an order to impose a 10% global tariff under Section 122 over and above our normal tariffs already being charged. And we're also initiating several Section 301 and other investigations to protect our country from unfair trading practices of other countries and companies.
So the president talked about, well, these are avenues that I did not take initially because they took longer than doing it under IEEPA. So how effective will these be? I'm sure the president is going to be on solid legal ground by initiating. But, I mean, why not do it this way in the first place?
It's a good point, John. And we were talking about it right before the president's press conference. In fact, he named the very same statutes you and I were talking about right before he came onto the stage. One reason why he will be on much firmer legal ground is because those laws, Section 232, Section 301, Super 301, they specifically use the word tariff. They specifically say the president has the authority to impose tariffs. It just narrows the circumstances, and it takes about a year. It takes longer to impose them. So, for example, the reason why President Trump, I think, used IEEPA in the first place is that it's a very fast-moving statute. It just requires a declaration of a national emergency. And then it gives a president almost unlimited powers in the area of international economics. Here, the president is going to have to say, I'm imposing a tariff on China because China has done A, B, and C, which he didn't have to do under IEEPA. And he's going to have to say, I'm going to impose tariffs on Mexico because of fentanyl or because of unfair trade practices or because they're surging certain kinds of products into our borders. That's going to take a while. It's going to take about a year. And, you know, as we know, President Trump in this area, like so many others, favors quick, decisive action, which is what most presidents favor as chief executives. Can I just make one other point, John, about this claim that the president was saying that the justices have somehow fallen under malign foreign influences? I think there's a much more charitable reading to what he was saying. I don't think he thinks that foreign companies were lobbying the justices or trying to influence them in any direct way. I think he's referring to this argument that we've heard made for many years that the justices have been seduced by a European view of law, by European views of globalization, that they're susceptible to changing the way they think and don't focus enough on the American Constitution and its text and history. And they're sometimes given to fancy European theories and philosophies about law, which favor activist judges sort of managing society. And I think that's the last thing that could describe this Roberts Court right now. They are trying to perform a more modest role. And they have been giving President Trump a number of wins in other places. But if I was President Trump's lawyers at DOJ, I would have been shuddering when I heard him say that, because President Trump has got a number of other big cases pending at the court, like whether it can fire the heads of independent commissions, whether it can fire a governor of the Federal Reserve Board, whether redistricting can go on. I think President Trump would be wise to no longer call the justices somehow tools of foreign influence.
John, to your point, if the president decides to move forward in a more incremental manner, meaning he is now going to designate individual countries and then justify tariffs based on national security threats, how likely is it that the Supreme Court will come back and check him on that?
It's a great question, John. And this is an important thing to keep in mind. Since those are different laws, this case was just narrowly written about the IEEPA statute. It does not challenge all those other trade laws that President Trump mentioned and that we've discussed on the show. No lower court has ever struck down the use of any of those statutes to impose tariffs. They've been regularly used by presidents of both parties. They have been affirmed by, in fact, when you read those statutes, what's happened is that Congress has given more and more tariff power in these areas
Very true.
to the president because they want the presidents to be more aggressive, punishing cheaters in international trade or addressing national security threats. The only difference between, I think, the congressional vision and the vision of this decision and what President Trump tried to do is that it has to be targeted country by country. A president just can't say everybody gets a 50% tariff in the world, no matter whether you have a trade deficit or trade surplus with us, whether you're a NATO ally or you're China.
Right. All right, John, thank you for your learned opinion. Much appreciated as always.
Thank you.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.